All right, if you are gearing up for the Queensland bar exam, you need to listen up. We are about to tackle one of the most fundamental and frankly most dangerous parts of day-to-day litigation, the affidavit. Getting these rules wrong isn't just a bad look, it can be absolutely fatal for your client's case, and it's a surefire way to trip up in your exams. So let's make sure that does not happen.
So here's our game plan. We're going to walk through the life of an affidavit. First, just getting the thing in the door, which is Rule 437. Then, what happens when it's in play in the courtroom, the critical cross-examination rules under Rule 439. Next up, your ethical duties as a gatekeeper under Rule 440. And finally, we are going to boil it all down to the absolute must-know takeaways for your exam.
Okay, let's jump right in with Rule 437. Now, on the surface, this looks so simple, so obvious. But trust me, this is a classic trap for young players, and it's where a case can completely fall apart before it even gets off the ground.
Here it is, Rule 437 of the UCPR. I want you to burn this one into your brain. Unless the court gives leave, an affidavit may be used in a proceeding only if it has been filed. Seems straightforward, doesn't it? But that one little word, filed, is where the whole thing can go sideways.
And that brings us to the million-dollar question. What on earth does filed actually mean? You know, can you just send your clerk down to the registry to drop a stack of papers on the counter and call it a day? Well, as one law firm found out the hard way, the answer is a big, resounding no.
Let's talk about the case of Irwin Holmes. Picture this. A solicitor hands a scanned copy of an affidavit over the counter, tells the registry the original's in the mail, but the original gets lost. A crucial, unmissable 21-day deadline under the Corporations Act comes and goes. And the court's final decision? That affidavit was never filed. The entire application was tossed out. Game over.
And Justice Mullins in that case spelled it out perfectly. Filing is not just dropping a document off. It is an official act. It requires acceptance by the registry, which is usually signified by them stamping it with the court seal. So the big takeaway from Rule 437 is this. You need to see that seal. Get that formal acceptance. Don't just drop it and hope for the best.
Okay, so you've successfully filed your affidavit. Congratulations. But its journey is far from over. Now we get to the hearing itself, and that brings us to Rule 439 and cross-examination. For your bar exam, you have to know the two different paths this rule can take. It's critical.
Pay very close attention here because this is all about timing. If you serve your affidavit properly, more than one clear business day before the hearing, the onus is on your opponent. They must serve a formal notice if they want to cross-examine your witness. That is Rule 439, Subrule 2. But if you serve late, less than 2 business days before, the tables completely turn. Your witness, the deponent, must be in court ready to be cross-examined. No notice required from the other side. That's Rule 439, Subrule 3. The difference is night and day.
So what's at stake here? Imagine you're in court. Your opponent just ambushed you with an affidavit this morning. You're relying on Rule 439, Subrule 3, ready to go, and the judge just says, no, sorry, no time for cross-examination. What happens then?
Well, that's exactly what happened in MBL v. JP. An affidavit was filed on the morning of the hearing, which, as we know, triggers Rule 439, Subrule 3. The trial judge shut down the request to cross-examine, and the Court of Appeal was, well, let's just say they were not happy. They found it was a clear denial of procedural fairness, and the decision was overturned. The lesson here is huge. The right to test evidence, especially late evidence, is fundamental. Getting Rule 439 wrong is an appealable error waiting to happen.
And that brings us to your higher duty. As a barrister, your duty to the court is paramount. It trumps your duty to your client. And Rule 4040 is the perfect example of this. It's all about your job to act as a gatekeeper and prevent scandalous or oppressive material from ever reaching the judge.
The absolute magic word here is relevant. Look, an affidavit can contain some truly awful, shocking, and cruel things about a person if those things are directly relevant to an issue in the case. But the moment it crosses the line into just slinging mud for the sake of it, when it has no real bearing on the outcome, that's when it becomes scandalous, and it's your job to say no.
And when a court is faced with this kind of material, Rule 440 gives it a very clear toolkit with 3 options. 1, it can just take the affidavit off the court file. 2, the more extreme option is to take it off the file and order it to be destroyed. Or 3, the surgical approach. Just strike out the nasty bits and leave the rest of the affidavit as is. You need to know these 3 powers for the exam.
And if you want a real-world example, look at Bell v. Bay Jesperson.
Here, the court did something really interesting. It ordered the affidavit removed from the file, placed in a sealed envelope, and ordered that it could not be opened without a further order from a judge. It just goes to show how seriously the courts take protecting their own process from abuse.
Okay, time to bring it all home. If you only have the brain space for a few key things from this whole explainer, make it what's coming up next. These are the 3 absolute non-negotiable rules you have to remember.
Let's drill this down. Rule 437. Filing is a formal act. It means acceptance by the registry. Get that stamp or your document might be worthless. Rule 439, cross-examination is all about timing. Know the difference between Subrule 2 and Subrule 3 cold. Getting it wrong can cause a mistrial. And Rule 440, you are the court's gatekeeper. If it's scandalous and irrelevant, it stays out, period. One more time, 437, 439, 440. Know them.
So let's finish with a quick pop quiz to get your brain working. You're at the courtroom door. Opposing counsel hands you a fresh affidavit. It is explosive, full of really inflammatory allegations. But as you're speed reading, you realize, wow, this is actually relevant. What are your immediate thoughts? What switches flick on in your head about Rule 439 and Rule 440? Being able to answer that question on your feet, that's how you pass the bar. Now get to it. Good luck.